Hey guys, thanks for watching this video. I want to share this very recent case, came out August 19 of this year from South Carolina. It's a Fair Credit Reporting Act case, FCRA case, and I want you to see it for really three reasons. One, it's a reminder that in a lot of federal court cases that are directly filed in federal court that involve consumer issues, the defendant will try to get the case thrown out saying that the plaintiff has not suffered a proper type of injury and legally they have no, quote, standing, end quote, to open the doors to the federal courthouse. This is also sometimes called a Spokeo challenge after the name of a U.S. Supreme Court case. And we see this very often, and so this is a good reminder of that. Second thing is the defendant here makes just a bizarre argument, but I'm seeing it more and more. And the argument basically says, okay, in your complaint, the thing that starts the lawsuit, you did not allege or lay out exactly what I did wrong and why I did it wrong. And so therefore you lose the case. So it would be like, let's use a personal injury context, because that's what I've done for almost 25 years now. And we certainly have issues with how those cases are handled, but we don't see the same types of silly arguments that we see credit bureaus and furnishers like this defendant warehouse company or debt collectors make. And so imagine this, you're at a traffic light, it's red, it's a two-lane road. You're stopped there at the traffic light, and some idiot comes driving along, heading towards you, runs the red light, veers into your lane, head-on collision. So you sue him, and imagine the defendant says, well, wait a minute. You did not allege in your complaint exactly why I ran the red light and exactly when and how I turned my steering wheel and exactly what speed I was going at every, foot increment as I entered the intersection and then veered into your lane, and exactly, how many inches from, the passenger side or the driver's side, the bumper that I made impact with your car, and the exact speed the response to that would be, hey, you idiot, I don't know. All I know is I was sitting there and you veered into my lane, crashed into me. We're going to find out when I take your deposition what you were thinking, what you were doing. Were you on your cell phone? Were you drunk? What was going on? But that's what consumer defendants, in other words, when we sue a debt collector under consumer law, we sue a furnisher under a consumer law, or mortgage company, they'll make these kind of ridiculous arguments. And I love the way the judge handles it here. And then the final thing I want you to see is that it's a good reminder that when a defendant cites to a previous case, which is typically how we argue these things, hey, judge, look at what happened in the Smith versus Jones case. You've got to go pull that case, because oftentimes the defendants in these types of cases will, how can I say this? They'll either misrepresent the way the decision is, or they'll leave out really important stuff. And so I learned this before I actually started practicing law. When I was still a law student, I read this brief from the other side. I thought, oh my goodness, we are like completely dead in this case, and it's a multi-million-dollar case. And I started pulling all the decisions. I go, they're not even remotely accurate about this. And so it taught me, never trust them. You have to go pull the case, read it yourself. So let's look at this case. So this is for a negligent, willful violation of the Fair Credit Reporting Act. And a lot of defendants were sued, but we're only talking about the furnisher here. This is a company called Warehouse. They are a furnisher because they furnish information to the credit bureaus. And this is a motion to dismiss, which is saying there's no way you can win based on your complaint. And the court says, I'm going to deny that. So factually, it's pretty simple case. Now, there's a little bit of confusion in my mind as to exactly what the plaintiff's saying. I've not gone back and pulled the complaint, but it doesn't really matter for our purposes. So she pulls her TransUnion report back in May of 2018, and she says there's a monthly payment of $70 on my account that was closed and charged off. And both sides told the judge closed and charged off means account's been closed, monthly payment is no longer due, but total amount remains due and owing. And so she sent letters to TransUnion and Equifax, which is the right way to do. You have to do it that way. You have to send your dispute letter to Equifax and TransUnion. Now you can send it to the furnisher also, but you have to send it to the credit reporting agency, the credit bureau. And then those guys will then forward it to the furnisher. If you don't do it that way, the furnisher has no liability under Fair Credit Reporting Act. And so many people think this is unfair. Surely that can't be the law. Yeah, that's the law. Okay, it's been the law for many, many years. And so she asked the credit bureaus to show this as $0 monthly payment. And so she alleges that the credit bureaus forwarded the letter to the furnisher warehouse, and then the results came back that they refused to report it as a $0. And so apparently she amended her complaint. I'm not exactly sure why. But then we had this motion to dismiss, and there was a hearing. As I'm recording this, it is August 24. So just, a couple of weeks ago, they held a hearing, and the judge has now written this opinion. And so we'll have a little bit of review here. Purpose of a 12B6 motion, so that's under Federal Rules Civil Procedure. Rule 12B6 is the motion to dismiss, saying that your complaint is not sufficient. And so the court reminds us that all you have to do in the lawsuit is a short and plain statement of your claim, but you have to have more than just the defendant did something wrong to me. You got to give a little more detail. Well, why do you do that? To give the defendant fair notice of what's the basis of your claim. And so it has to be sufficient factual matter to state a claim to relief that is plausible on its face. Well, what does that mean? So facially plausible, well, here's where we start getting into this. That allows the court to draw a reasonable inference defendant's liable, and something that alleges facts that are merely consistent with defendant's liability stops short of the line between possibility and plausibility. Now look, this can easily get into semantics, but the idea is that you've got to give enough that the judge says, okay, I could see that happening. Not just, is it possible? Well, if it's 1 in a billion, I guess it's within the realm of possibility, but it's got to be more than just possible. So the court says, well, look, I'm going to take the allegations as true, and any reasonable inference, I'll do that in favor of the plaintiff. And anyway, the rest of this, you can read it, but here's where we get into this, what's called Article 3 standing. So this is the Spokeo challenge. So the court says there are 3 elements that we're looking at. Almost always we're just fighting over element number 1. So that's an injury in fact. Number 2, fairly traceable to the conduct of the defendant. And number 3, it can be redressed by a judicial decision. And notice this, the burden of establishing these elements falls on the party invoking federal jurisdiction. And so if you file your case as the plaintiff in federal court, then you bear the burden of proving all this. Now, if we file in state court and somebody removes it to federal court, and that's how we do it, by the way, we file in state court, let it get removed to federal court, and then if they raise this, we go, okay, so you want to send it back to state court? And they go, oh, no, we'll withdraw our argument. So that's why we do it in state court, so we don't have to mess with this. And if a judge ever decided that we did not have enough to stay in federal court, well, hey, we just go back to state court, which we're fine there. So here we go. In this particular case, the injury in fact requirement, the injury must be particular and concrete. And so you cannot just have a bare procedural violation, divorce from any concrete harm, and satisfy that requirement. And the court says, well, that's all you've done. And the defendant says, she's unable to satisfy the injury in fact, and then the court says the injury must be de facto. That is, it must actually exist. So we're not talking about some hypothetical thing. You actually have the injury. And so what does she say here in this Fair Credit Reporting Act case? She says, I had damage to my credit and my emotional state. So I had emotional damages, mental anguish damages, same thing. And the defendant says, well, you did not allege that you sought credit and you were denied, which is not a requirement, but that's what they argue here. And the court says, while it may not be tangible, it is de facto, and it's more significant than just some bare procedural violation, and or some, what the defendant would argue, a technical violation. So what the court's talking about here, intangible, is, let's say that you were turned down for a great interest rate on refinancing, and you got a higher interest rate. Well, now you have some tangible damages that you can sort of write up on the board in front of the jury. Well, we don't always have that. Mental anguish is not tangible. A personal injury would be tangible. Mental anguish itself is not tangible. And the court looks at some previous decisions and says the threat of harm that bad credit imposes is recognizable. It exists. Here's another quote from Georgia. Even when there are no out-of-pocket expenses, humiliation, mental distress do constitute recoverable elements and damages. That's from this year in Middle District of Georgia. Here's another one from Georgia. Allegations suffered emotional and credit-related injuries are sufficient. Another one, mental distress damages are recoverable. And the court says this is good enough. And so here's the again, sort of a summary of the argument by the defendant. Plaintiff cannot automatically satisfy injury in fact just because the statute grants a person a right and purports to authorize that person to sue. And the court goes, that's true what you're saying, but you're disregarding the harm bad credit imposes, and you ignore one of the harms, which would be the emotional distress. So court denies that. And again, it's kind of tedious going through that, but understand that if you bring a case in federal court under a consumer protection statute, you will almost certainly get this type of argument. So again, from a strategic standpoint, we file our cases in state court. If they raise these arguments, we go, hey, do you want to just agree to send it back to state court? They will not do that. The reason is, if we tag somebody for a huge verdict in federal court, while the lawyers can be criticized for that, and the in-house lawyers for the company can be criticized, at least they can say, well, we did this in federal court. But if they left it in Alabama state court and they got popped for a big verdict there, people will go, well, what kind of moron would do that? You should have taken it to federal court. And so it's just this almost uncontrollable urge that they have. They have to take the case to federal court. And it just allows us to skip these kind of goofy arguments. So here's another argument. And this is something that is very annoying, but we're seeing it more and more. And I like what the judge did here. But first, let's look at the actual law. So it's 1681S-2B. And this is relating to the furnisher. What the furnisher must do after the furnisher receives notice of a consumer dispute from the credit bureau. So the consumer has to send the dispute to the credit bureau. Then the credit bureau must send the dispute to the furnisher. So if either one of those don't happen, then there's no liability under the Fair Credit Reporting Act. So if the consumer doesn't send it to the credit bureau, you can't sue under the Fair Credit Reporting Act. If the consumer sends it to the credit bureau, but the credit bureau does not send it to the furnisher, then there's no liability for the furnisher. So this is what we're talking about. After receiving notice of the dispute, then this says person, this would be the furnisher, shall do, and you can see there's a bunch of things here. So conduct an investigation, review all relevant information provided by the Consumer Reporting Agency, report the results of the investigation, and if the information is found to be inaccurate or incomplete, you modify that item, you delete that item, or you permanently block the reporting of that item. That's what you have to do as a furnisher. So the plaintiff says that the reporting creates a misleading impression, affected her ability to obtain credit, and the court said that's enough to sort of have standing here. And here's the argument that the defendant makes. Points out plaintiff cannot prevail on Fair Credit Reporting Act claim without demonstrating that had the furnisher conducted a reasonable investigation, the result would have been different. That is, the furnisher would have discovered that the information it reported was inaccurate or incomplete, triggering the obligation to correct. They cite an 11th Circuit case, and I'm pretty sure I've got coming up a video where we'll go through this case, this Phelps versus Wells Fargo. So the furnisher here, warehouse insists, must specify instances in which its actions or inactions caused her harm. And the court says, well, look, the plaintiff can't plead your specific errors during your internal investigation without discovery. So discovery is where we take a deposition, question somebody under oath. We send them written questions called interrogatories. Think of like an interrogation. We ask for documents, requests for production of documents. Sometimes we ask the defendant to admit or deny certain specific facts. Those are called requests for admissions. So the defendant here is saying, well, you didn't tell us what we did wrong. Well, there's no way the plaintiff can know that. The plaintiff has no idea what happened internally. All the plaintiff knows is that, furnisher, you had enough information that if you had done any type of reasonable investigation, you would have fixed this. Because you did not fix it, therefore your investigation was bad. And so this is the response from the consumer lawyer, and I think it's very good. Seeks to impose an impossible pleading standard as the consumer cannot know investigative procedures between warehouse and the Consumer Reporting Agency until she engages in discovery. And if you allowed this standard, it would prevent any consumer from filing any lawsuit under the FCRA, as no consumer would or could know such facts before engaging in discovery. So again, think of my silly little example with the guy running the red light and go, well, you have to say exactly what we did wrong. Well, you ran the red light, crossed into my lane. Okay, we'll figure out the details when you're swearing under oath. And the court says, look, you don't have information yet. You just filed this case. You've got to be able to take their deposition to get this information. Now, here's the third point that I want you to see. Warehouse attempts to convince the court present case similar to a case from Middle District, Georgia, in which the defendant's motion for summary judgment, and that's key, and I'll come back to that in just a second, was granted. It's called Keith versus Equifax. And the reason the defendant cited this, and this is good that they did this, both cases involve plaintiffs asserting the furnisher violated the FCRA by listing monthly payments despite the account being closed and charged off. And so Warehouse argues that the case should be dismissed. So first thing I'll point out is, and I don't know which is accurate because I haven't read this case, but I will go read this case. And if you had this case cited against you, you would need to go pull it and read it. And so that's what we'll do. But notice what the court says here is motion for summary judgment. Well, if that's accurate, a motion for summary judgment is 99% of the time after discovery has taken place. And you can't just rely on what you allege in your complaint. In a motion to dismiss, that's all you're relying on is what is in your complaint. But at a motion for summary judgment, we're looking for deposition testimony, interrogatory answers. It's a harder standard for the plaintiff to survive summary judgment. And so we always have to be careful about a summary judgment order where the court says, well, you didn't come up with enough evidence, versus, well, all I have to do in a motion to dismiss is plead this or allege it in here. And then the court says, well, aside from the fact that it's not binding upon this court, so the appellate court decision would be binding, but this is from a different circuit. So 11th Circuit is Florida, Georgia, Alabama. South Carolina, I actually forget which circuit it is, but it's saying, well, that's from a different state, a different circuit, and even if it was from the same courthouse, a different judge is not technically binding, but they certainly give that a lot of respect. So the plaintiff says notice was provided to the furnisher upon information and belief. That's just a legal phrase that a lot of people use. They're like, well, I can't prove this. I'm just going to say upon information and belief. And here, the plaintiff, Burns, gave written notice to both TransUnion and Equifax, who then forwarded it to Warehouse. So the plaintiff here is saying it definitively. Oh, they got notice. Okay. And the Middle District, Georgia did not consider any arguments from the plaintiff because he failed to respond to the defendant's motion to dismiss. Now, again, we'd want to look at this because this makes it sound like it's a motion to dismiss. Up here it says motion for summary judgment. It may just be a typo, or when this was sort of put on Google Scholar, it might have been an error. So we need to go look at that case and see what it's saying. But here the court's saying, no, this is different because you got somebody who didn't even respond to the argument. So that leaves the court in this Keith case to say, well, I'm just going to go with what the defendant says here. So again, when a decision cited, particularly one that looks like it's very, very similar to yours, you've got to go look at that case and say, is it really that similar, or is there something I'm missing here? So I'm going to hallucinate that Warehouse, the furnisher in this Burns case, did not say, oh, and by the way, Judge, the plaintiff didn't even respond in this case I'm citing. I suspect they left that part out. So the motion to dismiss is denied here. So I hope this is helpful. Remember the 3 points that I wanted you to take. Obviously, you can take more points from this, but just a reminder about that Spokeo or standing challenge. This idea that, well, even though you haven't gotten us to swear under oath in a deposition, we expect you to know every detail of the secret process that only we, the defendant, know. And the court rejects that. And then third, when they cite a case, you've got to go read that case and make sure it really says what they say it says, and is there something important that's been left out. So appreciate you guys watching this video, and I will catch you in the next one. Have a great day. Bye-bye.